greetings to one and all present here. I hope everyone is doing good. I, Dr. Kazuma Mizukoshi, Assistant Professor, Tapa School of Liberal Arts and Sciences, Tapa University, Patiala, will be enlightening you all on the topic, the customary international law. Let's begin with a simple question: why we study customary international law? Customary international law, hereinafter CIL, plays an important role, especially of filling lacunae in codified international law, such as treaties or charters. Nevertheless, the status of the CIL has not been firmly established yet. This may be because the very nature of CIL lies in its invisibleness. In other words, the being uncodified, so that it literally means customary. As such, it is not easy or even possible to distinguish the non-customary practice from the customary practice, which were referred by Article 38(1)(c) of the Statute of the International Court of Justice. This difficulty, in turn, often intensifies rather than pacifies the conflicts between the states or other actors, coupled with counter-interpretation of what custom should be. CIL is in this regard nothing other than a puzzle itself. Many people see it important, but so do they see it as troublesome too. As we observe the increasing trends of polarization in both domestic and international politics, what is the raison d'etre of CIL? To address this question, let me raise a fundamental question initially. What is customary international law? Let's move on to discuss major theories of customary international law accordingly. So far in the legal studies of customary international law, have experts generally stood on either pragmatism, idealism, or empiricism. While all philosophical stances have their own merits, they all lack the ontology of customary international law. As such, the CIL should look like quite differently if we go through their discussions. The first framework is pragmatism. The International Law Commission, hereinafter ILC, expert body of the United Nations, to initiate legal studies and make advices accordingly to encourage the development of the international law and its codification, has so far stood on the approach of the classic pragmatism. Customary international law is there, and their mission is to identify it through the sense experience of state practice and opinio juris, acceptance as law. This approach stands on the conventional understanding of CIL, illustrated by Article 38(2) of the Statute of the Permanent Court of International Justice, hereinafter PCIJ, and Article 38.1b of the Statute of the International Court of Justice, hereinafter ICJ, which itself was prepared for the Council of the League of Nations by an advisory committee of jurists in 1920. Article 38(2) reads, "International custom as evidence of a general practice accepted as law," and so does Article 38(1)b exactly with the same phrase. To determine the existence and the content of such a rule of customary international law, the ILC stressed the two elements: general practice and its acceptance as law or opinio juris. The general practice particularly refers to the conduct of state and in certain cases of international organizations, which include diplomatic acts and correspondence, conduct in connection with resolutions adopted by an international organization or at an intergovernmental conference, conduct in connection with treaties, executive conduct, legislative and administrative acts, and the decisions of national courts. Furthermore, to be identified as the source of CIL, the general practice should have been both extensive and virtually uniform. Extensiveness and the uniformness were so recognized to invoke a belief of obligation, thus allegedly helping us to distinguish the concerned acts of the state from its other acts or statements, if verbal practice could also compose a part of the general practice. This focus of the ILC on identifying the components of the CIL reflects its pragmatism. An unofficial document survey under the heading Items that should not be inscribed on the ILC's agenda, for example, described as such that the formation of customary international law deeply involved theoretical, thus non-practical questions, which would often draw abstract solutions not immediately relevant for those who rather concerned the application, not ascription of customary international law to their own domains of expertise, such as domestic courts, judges, or governmental officials working for ministries other than the Ministry of Foreign Affairs. While the efforts of the ILC to give intelligible advices to practitioners make sense, such advices may bring further confusions indeed. The exemplary cases of the general practice are all about the official or unofficial statements or text, which may certainly reveal the thoughts or beliefs on how CIL should look like. But the dominant way in which we talk about international law and the widespread acceptance of certain doctrines does not equal truth. Here, another paradigm stands up, that is idealism. One of the influential frameworks is of Aspremont belief theory. Jean d'Aspremont critically read the 2018 conclusions of the ILC and concluded it as monolithic or reductionist, as the definition of the Advisory Committee of Jurists for the PCIJ on CIL. While the 2018 ILC conclusions defined CIL in such a way that the CIL would have two constituent elements, it ended up with the same sources through which both general practice and the opinio juris of CIL could be inferred: expressed statements or thoughts of the state. As such, the grounding of CIL in a social reality captured through practice and opinio juris can only be upheld if there was a moment in the past where the practice and opinio juris of the state have coalesced in a way that generates customary international law. This would be why d'Aspremont came to define CIL as the organized clusters of modes of legal reasoning, leaving the behavioral element of CIL out of analysis. For d'Aspremont, scientific analysis on the existence of such an organized clusters of legal reasoning can be misleading, because the very moment when CIL is reformed or formed has never been exactly identified nor traced, but has been presupposed at best. The ILC, for example, has consciously avoided to address the formation of CIL, not only because it inevitably involves the theoretical questions, which may not draw the practically applicable solutions, but also given its presupposition of CIL formation. The presupposition of a custom-making moment is thereby the key to understand CIL more deeply by assuming the belief of CIL along with two moments. The moment when the CIL was formed in the past, and another moment when it is applied in the present. So this two-dimensional temporality enables to pave the new dimension of empirical analysis. That is interpretation. Because one presupposes a custom-making moment in the past, one can think of CIL as a tangible artifact in the present, which can therefore be subject to an autonomous and neatly organized interpretation process. Because one presupposes a custom-making moment in the past, one can think of CIL as a tangible artifact in the present, which can therefore be subject to an autonomous and neatly organized interpretative process. So let's talk about judicial empiricism. Although Daspleymont's radical turn to the presupposition of CIL formation may certainly fill in the gap between the two-element theoretical framework and the pragmatic solution to identify the evidence of CIL. It triggers a new source of confusions, that is, counter-interpretation. There is an interrelation between law formation and law interpretation. Anthony Damat stated, "So is this interrelation more troublesome than beneficial when we turn our attentions to CIL? Indeed, because the CIL is not tangible and could change continuously, interpreting the CIL in a way which runs counter to the established understanding of its general practice might thus be possible. Such a counter-interpretation may lose the validity of the practice as the source of the CIL, as stated by the 2018 ILC conclusions. But it may also pave the way to the revision of the CIL in a cumulative manner." The arbitrator in the Island of the Palmas case described that the same principle which subject the act the creative right to the law in force at the time the right arises demands that the existence of the right. As such, it is certainly possible to interpret the constitutive, the element of the CIL differently, the conditional to the aims of acts in concern. Those aims of acts, in turn, may be figured out in response to both national and international circumstances. While there exist the multiple proportions of why the state behaves in such a way, they can be roughly sorted out into two paradigms. First, general practice of the states and/or international organizations should have defining features to reveal the so-called international custom. Second, the nature of the general practice should explain the very existence of such custom instead. The first paradigm focuses on opinio juris and seeks to establish a solid basis through which scholars can empirically examine whether opinio juris, if any sense, can be plausibly upheld. Beheim is in this regard in the forefront of the paradigm. Opinio juris for him does not necessarily indicate the tacit agreement through which the states and international organizations seek to achieve something actively. Rather, it represents a quasi-consensual element in that the states could equally choose to answer the question, "Did you just behave that way because you thought there is a legal obligation to do so. A sense of obligation thus becomes a proxy for the existence of custom. Another approach pioneered by Kammerhofer focuses on the general practice of the state. The real problem of customary international law is the exact content of those rules which regulate the creation of CIL. To seriously address this problem, Kammerhofer stressed a behavioral approach. Customs must be an observance of the voting the prescription or exercise of the voting right, stated Kammerhofer clearly. Explicit in this argument corresponds to state that simply saying not torturing, for example, cannot be the evidence of non-torturing practice, because the very object of customs, here torturing, involve the conduct or behavior of the actors in concern. As such, even if the states or international organizations indicate a tacit agreement or sense of obligations through their statements, if they behave irregularly so that their acts are unable to deliver the coherent message, their practice does not actually help us delineate the formation of international custom and eventually CIL. While these two paradigms can be read as a significant step towards the revival of scientific approaches, or more exactly the classic empiricism, their conclusions are subject to the so-called epistemological fallacy. The first paradigm, for example, cannot answer clearly that, aside from methodological possibility or impossibility, why a sense of obligation, not of positive aims, should be a proxy for opinio juris. Likewise, for the second paradigm, how can we understand whether the observed regularity of verbal or behavioral acts is a part of truth, so understood as international custom? Or more critically, is CIL something what we can only experience or sense? These questions indicate that the ontology of CIL should be discussed in advance to develop methodologies. Here, the ontology involves the two meta-questions. First, to what extent does CIL in general have its own existence basis? Second, to what extent is custom independent of actions and or statements of the states and international organizations? Standing on the critical realism, I will propose a new ontological framework for the empirical analysis of CIL in the next sections, and then conclude this lecture. Answers to the first question, the existential basis of CIL, may be positive the extent to which we can imagine that international custom could be resilient to the irregularity of actions and or statements by the states or international organizations. So far in the CIL literature have both pragmatists like ILC jurists and empirical scholars like Kammerhofer or Beheim stressed the regularity of the verbal or behavioral practice as a necessary element of CIL. Rest idealists like Dasplemmont also acknowledge that such regularity by presupposing the binding forces of custom. I argue in this lecture that the regularity or constant conjunction of actions and or statements is neither sufficient nor necessary to account for the very existence of CIL. But how plausible is such an argument? Legal history could answer to the question. The simplest, the truism, lies in the fact that The later formally ascertained law was itself based upon the pre-existing customs, the existence and authority of which was accounted for independently of the persons who came to proclaim them. Law and order thus initially appeared as custom, arising freely and unassisted through the simultaneous interactions of individuals. It is impossible to suppose that the customs of any race or tribe remained unaltered during the whole of the long, in some instances the immense, interval between their declaration by a patriarchal monarch, such as primitive family-based society, and their publication in writing, like the 12 Tables of Rome, because the very composition of such a collective unit, for example, the family, city, the state, or even international community of states, continuously changes so as to bring new interactions between the components. The dual nature of the interactions that states have with both internal and external actors, including interest groups, opposition groups, or international organizations, I argue in this lecture, provide an ontological basis for CIL. The duality indicates that norms or principles to govern both domestic and international societies do not necessarily overlap. Some former colonies of European countries or some satellite republics of the USSR, for example, had experienced the turbulent time in which, after independence, authoritarian leaders sought to rewrite constitutions as they thought most fitted to their political goals, restricting the human rights to some extent. This, however, does not mean that the political leaders could do whatever they would like, because some authoritarian leaders had to face both internal and external pressures to change the everyday practice of politics through democratization. Explicit in this context is that how the states interact with their nations and also the counterparts should be determined by the calculation of domestic support to the government and or the stances of international counterparts. Let me conclude the lecture. So far in this lecture, as I focused on customary international law or CIL, some practitioners like ILC jurists have defined the CIL as the subject of identification, whilst the several scholars like D'Aspremont denied such a conceptualization and rather focused on its creation. Aside from this doctrinal debate, other scholars have sought to establish an alternative approach which attempts to empirically demonstrate the existence of the custom, a proxy for CIL. While this last approach sounds analytically reasonable, it lacks ontology to account for why particular sense experiences of obligations, feeling, or of regularity are significant as the evidence of custom. As such, standing on critical realism, I introduced an alternative framework through which both internal and external interactions that the states have would provide an ontological basis for CIL. In other words, custom and the CIL should be subject to the actions and or statements of the states, which are in turn determined by the calculation of domestic support to governments and or the stances of international counterparts. Thank you everyone for your valuable time and attention. I would appreciate the opportunity to speak and share my views with you today. Thanks once again and take care and God bless you all.